Welcome to the Create Protect podcast with attorney Tamara Bennett, addressing legal and business issues in the areas of music publishing, copyright law, trademark law, and brand management. My name is Catherine, and joining me this afternoon is Tamara Bennett. We've all been enjoying the heated political campaign trail this fall between John McCain and Barack Obama. While politics may seem far away from an entertainment law office, there are important copyright and entertainment law issues to keep in mind. For example, McCain's campaign has used Heart's song Barracuda as an unofficial theme song for Sarah Palin. Depending upon the use, there are several implications for this, such as ASCAP performance licenses. What about synchronization licenses for the master and the song? And what about right of publicity? As part of our new Ask the Expert segment, the following questions were submitted by a student at Goucher College. Let's get started. Tamara, does the ASCAP license allowing the venue to play recorded music cover a nationally televised event?
You know, that's a great question, Catherine. ASCAP licenses are for public performance of a song. That can be a performance at a live event, a performance where we hear a song on the radio. All of those are public performances. ASCAP, BMI, and CSAC are the three entities that issue those licenses on the behalf of the owners of songs. So in this case, the venue or the group that was holding the event would pay a public performance fee to either ASCAP, BMI, or CSAC so that they could play live or recorded music during their event. The venue license is just for the venue. If the event is then rebroadcast on television or some other satellite, there's going to be a different license that's going to be paid by the retransmission company or by that broadcast entity.
Does the use of the song require a separate synchronization license from the publishers and a master use license from the owner of the recording over and beyond the payment of the public performance fee?
Well, a sync license really only comes into play when we have images that are recorded in a time relation to the song. So it would be if it's a song used in a movie or a song used in a commercial or on TV. But there's no sync license required for the actual live performance of the song on a television show. So it would only need a sync license if it was then recorded and redistributed at some later time. So in this case, there wouldn't have been a need for a sync license for the master or the song.
Okay. Is there any validity to the argument that regardless of the broadcasting, a synchronization license should have been obtained due to the series of images appearing on the screen while the song was being played?
In this case, the song Barracuda was played throughout the convention hall at the Republican National Convention after Sarah Palin's speech, but it was not specifically synchronized with any pre-recorded images. There were images that were playing in the background, but no images played concurrently and synchronized to the song. There were other uses that the campaign has used at rallies, but again, I'm not aware of a specific use where there was an actual synchronization of the images to the song.
Let's talk about right of publicity. Does Heart stand a chance if they were to sue the McCain campaign for violation of right to publicity, as the song may become identified with Palin?
You know, right of publicity arguments are often hard to achieve and win on. They're governed not by federal law but by individual state laws, and each state's law vary in some respect. In general, there's four elements to the claim that if Heart wanted to bring such an action, they would have to meet. They would have to show that in some way their identity was used, that their name and likeness was used to advantage, in this case, the campaign of McCain and Palin, and that there was a lack of consent and that they were injured. So the first question really becomes, is the song synonymous with their name and likeness? And that's a fact question that might be hard for Heart to establish. I mean, it was a very popular song. It was kind of one of their classics, but again, we don't know if they could really establish that level of identity of the song to their name and likeness. Then was their likeness used for McCain's advantage, which would be a fact question if they were to go to court. And it might be difficult to prove, and arguably there could be an option that there was a commercial gain to the campaign, but probably unlikely. People did not go to a rally or the convention to hear what music was being played in the background. Really, the music was just a backdrop. So it's difficult that they could say that there was some commercial gain to the campaign or some loss that they suffered. And was there a lack of consent? Well, there wasn't any consent, but again, it goes to the fact, was consent really necessary? And then how would Hart actually show they were damaged, other than they really just didn't want to be associated with the Republican campaign? I just don't think they could really meet the elements of a right of publicity claim.
Let's say Hart did want to file a lawsuit, and since the right to publicity laws vary from state to state, in which state would the artist file suit? Would that be their home state, the states in which each violation took place?
In this case, they actually could do some of what we call in litigation some forum shopping. They have some different options where they could file a lawsuit. I mean, they could file a lawsuit where they reside. They could file a lawsuit where the damages occurred. So that could mean in the various states where their song was used and they felt like their right of publicity was damaged, they could go to that state, look and see if their right of publicity law might be more favorable to them, and attempt to move forward with an action there.
Is Hart the only recording artist or songwriters concerned about these issues?
Well, it's an amazing thing. John McCain has picked a lot of songs from folks that aren't really excited about being associated in some fashion with his campaign. Over the last couple of weeks, Bon Jovi, the Foo Fighters, Boston, and John Mellencamp have raised similar issues and asked for the campaign to stop using their music in conjunction with their rallies and events. And again, it kind of goes back to the real issue is it's not so much that it's an act of copyright infringement or right of publicity. It's really the fact that the individual artists do not want to be associated with the Republican ticket. And on these, I don't think there's been any out-of-bounds use by the ticket. But we can also kind of look at an actual lawsuit that's been filed in the past month brought by Jackson Browne. There was an actual campaign commercial, in which his song was synchronized with moving images in a campaign ad for John McCain. This was done without his permission. No license request was asked or denied, and obviously Jackson Browne would have denied such a request, and he could have. So he has filed a lawsuit for copyright infringement for the song against the McCain campaign, against the Republican National Convention, and another entity that was involved in producing the ad. And I really think Jackson Browne has a valid claim for copyright infringement because of the fact the work was actually synchronized, which is very different than the public performance of the songs raised by Hart and Bon Jovi and Foo Fighters and the others.
Okay. And you can find out more about that case on our blog, which is www.createprotect.com. And Tamara, I'd like to thank you so much for your insight today, and thank you also to our student for sending in questions to Ask the Expert. And if you have any questions that can be answered on an upcoming podcast or blog post, please email them to info@tbennettlaw.com. That is www.info@tbennettlaw.com. And thank you for joining us again on this edition of the Create Protect podcast.